Welcome to the Cooper Union and to its great hall. I'm David Greenstein, Director of Public Programs, and I'm happy to see you here for the fourth in our series of J. Iselin Memorial Lectures, which celebrate the memory of the 10th president of the Cooper Union, John J. Iselin, who was a great journalist and editor, as well as the president of Channel 13, when he made it the largest and greatest public television station in the country. Our speaker, Burt Neuborne, is the Inez Milholland Professor of Law at New York University. And for his fourth lecture on the Constitution, he'll be talking about religious freedom, divine madness. Next week, it will be the right to bear arms, the riddle of the Second Amendment. So we hope to see you for the rest of this series, which proceeds every Thursday except for Thanksgiving until December 13th. Professor Neuborne.
Thank you all again for coming. I appreciate the support for my constitutional marathon. Thanks again to Lee Iselin and to Cooper Union for making it possible for me to try to run it. Let's see if I can finish it. In lecture one, I suggested that the characteristically different value hierarchies held by contemporary Republicans and Democrats, primarily in the area of the relationship between autonomy, equality, stability, and change, would lead justices to break constitutional ties in hard cases in characteristically Republican and Democratic manners, leading over time to discernibly different Democratic and Republican constitutions. I recognized two important caveats. Most importantly, I noted the existence of a consensus constitution formed by clear text, clear precedent, and widely shared values. Cases falling under the consensus constitution do not involve value-driven tie-breaking, and most cases fall under that category. I also recognized that Republican and Democratic Party labels often carry different connotations in the past than they do today. Once upon a time, my friends, there were liberal and conservative factions in both parties. Liberal Republicans like Earl Warren, John Paul Stevens, and David Souter, and possibly Harry Blackmun and Sandra Day O'Connor, held values that might make them more comfortable in today's Democratic Party than in the more conservative Republican Party in their day. Thus, I treat Warren, Stevens, and Souter as honorary Democrats in working out the content of the Republican and Democratic constitutions. I leave Blackmun and O'Connor in the Republican arena because I'm just not sure enough to move them. In lecture two, I applied the Republican and Democratic constitutions to the structuring of American democracy. And I concluded that the justices had built a profoundly dysfunctional democracy, resting principally on the Republican conception of the relationship between democracy and the Constitution. Last week in lecture three, I applied the Republican and Democratic constitutions to free speech and argued that a close textual reading of the deep structure of the First Amendment, I called it Madison's lost music, might aid us in reading it more precisely. This week I'll try to apply the Republican and Democratic constitutions to the issues of religious freedom posed in the First Amendment's two religion clauses. The Bill of Rights begins with the First Amendment, but the First Amendment begins with the two religion clauses: a ban on enacting laws respecting an establishment of religion and a guarantee of the free exercise of religion. Lee Iselin reminded me last week that I should have ended last week's lecture by reading you a poem, since I had read one in the middle. So let me make up for that by reading you that poem now. And the poem is the First Amendment. The text of the First Amendment, 45 words, provides, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those are the two religion clauses, establishment, free exercise. Or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. You recall last week I said that that organization couldn't be random. It was an inside-out organization that starts in the interior precincts of the human conscience and moves in concentric circles of increasing collaboration with others to the point where you formally interact with the government. And that really what Madison was describing in that magnificent poem is the life cycle of a democratic idea that begins in the mind of a free citizen, that moves to speech through articulation, that moves through press to mass circulation, that moves through assembly to a political organization, and that moves through petition for redress of grievances to final adoption by the state. And I said that couldn't be a coincidence. The founders did not throw a pot of ink at the wall and have the splatter be the determining factor of the order. But they put the two religion clauses first because they thought that was the most important. So I think Madison's decision to put the religious freedom clauses first obviously was not a coincidence. More than a century before Freud, Madison and the founders understood that the mainspring of human behavior resides in the interior precincts of the human mind. Freud, living in 19th century fin de siècle Vienna, thought the mainspring was sex. That tells you something about Vienna. Ronald Reagan, living in 20th century fin de siècle California, thought the mainspring was greed. That tells you something about California. James Madison, living in 18th century Virginia, at the end of the 18th century in Virginia, obviously a more dignified place and time, was sure that it was the commands of conscience, both religious and secular. And so Madison's conception of the religion clauses is an effort to deal with what he believed was the genuine mainspring of human behavior, the instincts that made us do what we do. That Freud said was sex, and Reagan said it was greed, Madison said it was conscience. If it had been up to Madison, the First Amendment would have opened with three clauses: an establishment clause, a free exercise clause, and a freedom of conscience clause. The original version of the First Amendment that Madison presented to Congress on June 8, 1789, contained the conscience clause. And throughout the drafting process, the three clauses rotated in and out of the text. Sometimes the free exercise clause was discarded in favor of the conscience clause. Sometimes the conscience clause was discarded and bumped in favor of the free exercise clause. The two were clearly seen by many of the delegates to be redundant with one another, and they kept bouncing one or another out of the text. The version that passed the House and went to the Senate had all three clauses. Had an establishment clause, a free exercise clause, and a conscience clause. The Senate deleted Madison's proposed conscience clause at the very last minute, leaving establishment clause and free exercise clause as the two religion clauses that open the document. Now, since the Senate's deliberations were secret, we'll never know precisely why the conscience clause was dumped. I like to think, though, it was because the senators believed that the conscience clause was redundant. Citizens were free to live in accordance with the commands of conscience, religious and or secular. But Madison also understood that the religious impulse had a darker side, capable of driving true believers to inflict unspeakable cruelties on non-believers. 16th and 17th century England and France had been religious bloodbaths, with Catholics and Protestants killing each other in droves and both killing Jews as quickly as they could lay their hands on them. John Rawls, the leading American legal philosopher of the 20th century, reminds us that the 18th century commitment to religious toleration that emerges in the religion clauses was really an exhausted religious truce flowing from the mutual recognition by Europe's Catholics and Protestants that neither could kill the other entirely. So they made a truce. And that truce comes down to us in the sublime and luminous idea of religious toleration. But before we think that we invented religious toleration, and before we are terribly proud of it, you should remember that it is an exhausted truce that succeeded a terrible bloodbath. Recent history had taught the founders that true believers had often used the engine of the state to persecute, harass, and even annihilate non-believers. So Madison sought to protect his ideal commonwealth from the reenactment of such a religious tragedy by building his now famous wall between church and state. Even before there was a Bill of Rights, in Article 6, Clause 3 of the Constitution, one of the few protections of civil liberties in the original text of the 1787 Constitution, there's a provision that forbids religious tests for public office. Madison was starting to build his wall even then. The First Amendment Establishment Clause takes the idea of separation between church and state one step further by forbidding religiously motivated public officials from using their offices to impose their religious beliefs on others. Thus, the two religion clauses function in tandem to assure freedom of and freedom from the most powerful psychological force known to the founders, the command of God. The tale of Moscow's Church of Christ the Savior, I think, illustrates both sides of Madison's wisdom. And it's a tale worth telling because it's a tale not known. The church was intended as a memorial to Napoleon's defeat by Russia in 1812. It wasn't completed until 1860, it wasn't formally consecrated until 1883, although Tchaikovsky's 1812 overture received its premiere there in 1882, just as the structure was being finished. The bejeweled and marble interior, the incredibly elaborate and rococo interior, was among the most lavish in church history, and it immediately propelled the Church of Christ the Savior to the center of Russian religious life. It drew Russian Orthodox believers for baptism and marriage from all parts of the country. The dome contained 40 tons of electroplated gold, embellished in various configurations. In 1930, Stalin, desperate for cash, and in the midst of a purge of the churches, ordered the Church of Christ the Savior dynamited, and the jewels and precious metals, especially the Golden Dome, confiscated by the state. Demolition was finally completed in 1937. In its place, Stalin ordered the construction of a secular Palace of the Soviets, a huge modernistic structure that was designed to celebrate the triumph of communism over superstition. Excavation for the enormous new building was interrupted by World War II and was only fitfully resumed during the waning post-war years of Stalin's power. When Khrushchev eventually succeeded Stalin, he inherited an enormous hole in the ground, which he decided to turn into an immense Moscow municipal swimming pool. In 1988, in my capacity as National Legal Director of the ACLU, I visited Moscow as a member of a delegation discussing the rule of law with Soviet counterparts. Now, it turned out that the two countries' delegates held very different ideas about what the rule of law meant. We saw the idea as an assurance that those in power would be bound by law in dealing with the people. The Soviets saw it as an assurance that the people would be bound by law to obey those in power. So it goes. I noticed the enormous swimming pool on the drive-in from Moscow Airport. And although it was a very chilly, rainy day, I could see crowds of people in and around the pool, which stretched for what seemed like miles. I wryly commented to my Russian guide that her countrymen were hardier than mine. Americans, I laughed, would never go swimming in such chilly weather. Now, the guide looked around very carefully to see whether anybody was listening, and she smiled and she shook her head. "You don't understand," she said. "They're not swimming. They're baptizing their children." Stalin may have dynamited the Church of Christ the Savior, but people still come from all over Russia to be married and baptized in the swimming pool built over its ruins. Score one for Madison's prescient understanding of the unquenchable power of the religious spirit. which is what the Free Exercise Clause is all about. It understands that unquenchable spirit and tries to protect people who are in its grip. In 1990, but the story doesn't end there. If it ended there, it would be a very nice, happy story. In 1990, with the fall of the Soviet Union, Boris Yeltsin began rebuilding a more modest but still impressive church over the municipal swimming pool. And it was completed in 1994, and immediately the rebuilt Church of Christ the Savior became a center of Russian Orthodox religious life. This time, though, there was an important difference. This time, the clergy, especially the presiding metropolitan bishop, operated as close allies of the Russian state. When Valery Putin took over, he used the state-supported Russian Orthodox Church as an arm of government, deploying religion as a form of social control. And the link between the Russian Orthodox Church and President Putin was particularly intense in the person of the metropolitan bishop of the Church of Christ the Savior, who vigorously urged Putin's re-election and condemned demonstrations seeking greater freedom that were taking place in Moscow. Now, last year, 3 young women, politically active members of an all-group punk rock called Pussy Riot, staged a 40-second music and dance routine in the nave of the church. The routine was entitled "Virgin Mary, Chase Out Putin," chanting opposition to Putin and his use of the church as an arm of the state. No services were underway, and the church was almost deserted. In an appalling overreaction, the 3 young women were convicted not of the minor administrative offense of disorderly conduct, which would have been appropriate because they didn't have permission, but of the felony of outraging religious sensibilities, and they were sentenced to 2 years in a Russian labor camp. Score another one for Madison's pragmatic understanding of the state's capacity to harness the darker side of the religious impulse. Now, as I noted last week, it's also why American free speech law is so nervous about punishing speakers for offending hearers' sensibilities. Thus, the 2 religion clauses are designed to protect true believers who choose to baptize their children in a place where a church once stood, and to protect those children from an effort to turn the rebuilt church into a state-run engine of political and religious orthodoxy. So despite the centrality of religious conscience at the heart of the religion clauses, at the heart of the Constitution, reading the 2 religion clauses poses something of an enigma, because they send conflicting signals about the Constitution's attitude toward religion. The ban on enacting laws respecting an establishment of religion is deeply suspicious of religion, guaranteeing Americans the right to be free from involuntary support for or adherence to religion imposed upon them by the government. The second clause, the ban on enacting laws that deny the free exercise of religion, is deeply supportive of religion, guaranteeing Americans the right to practice their religion vigorously and openly, free from governmental interference. How, if at all, can the apparent tension between those 2 clauses be resolved? Now, answering that question has given rise to the principal difference between the Republican and Democratic approaches to the religion clauses. The Republican justices perceive, correctly I believe, the Republican justices perceive a serious tension between the 2 clauses. They note correctly that government efforts to assist the free exercise of religion may cross the line and become forbidden establishments, and that what appears to be a forbidden establishment may also be seen as a government effort to make it easier for a private citizen to freely exercise her religion. Consider for a moment the constitutionality of government-paid military chaplains. Now, paying a priest or a rabbi a government salary to minister to soldiers is unquestionably a form of government aid to religion that would ordinarily be barred by the Establishment Clause. Indeed, that's exactly how an established religion operates, with the government using general tax funds to subsidize the operating expenses of a favored church or favored collection of churches, thereby requiring taxpayers to support religious beliefs that they may not share. Madison thought that the state-paid military chaplains were unconstitutional and said so back at the end of the 18th century. But paying the salary of clergy in the context of military life or prisons may be necessary to permit members of the armed forces or the inmates of a prison to exercise their religion freely. Indeed, a failure to provide for military or prison chaplains in state-created settings where the soldiers or the prisoners lack the freedom of movement to find religious solace elsewhere might well be attacked as a violation of the Free Exercise Clause. So not surprisingly, no objection has arisen to military or prison chaplains in modern time, but the tension between the Free Exercise and Establishment Clause is apparent every time you think about it. Now, it's harder to make the free exercise argument for government-subsidized legislative chaplains who open each legislative session with a prayer. Unlike prisoners or soldiers, since legislators still retain freedom of movement, although sometimes I think a lot of them perhaps should be forced to use prison chaplains. But since legislators still retain freedom of movement, it's unclear why they would need a government-paid in-house chaplain. Nevertheless, in a case called Marsh v. Chambers that I lost, the Supreme Court upheld the office of chaplain of the Nebraska legislature, who begins each legislative session with a prayer. The Supreme Court relied on the fact that congressional chaplains had officiated during Washington's administration and that Madison, as a congressman, had actually voted for the process. The court's majority conveniently forgot, though, that an older James Madison had profusely apologized for having voted for the practice, admitting that he caved in to political pressure. As the chaplaincy cases illustrate, though, there is just no escape from the paradox of the two religion clauses that sometimes pull in such extraordinarily different directions. How can we deal with that paradox? Republican justices tend to try to tame the paradox by leveling down the constitutional protection in both clauses so they don't clash. Republican justices view the clauses as essentially forbidding improperly motivated, irrational, or discriminatory action affecting religion. Improperly motivated, irrational, or discriminatory government action affecting religion. So in effect, the Republican approach turns both clauses into equality guarantees, assuring that religion will be treated no better, but no worse than any other idea in society. Democratic justices tend to deny that the religion clauses are in tension, or at least fundamental conflict with one another. They argue that religion, including secular conscience, should be treated better than other ideas when free exercise is at stake, and worse than other ideas when Establishment Clause issues are at stake. They claim the two clauses reflect Madison's profound understanding of the power of religious belief as a form of divine madness. And I say that with respect. They argue that an individual in the grip of this extraordinarily powerful force, the force that allowed people to bring their children to be baptized in a swimming pool, long after the church had been dynamited, this enormously powerful driving force that Madison thought was the elemental driving force in the human personality. An individual in the grip of divine madness who is pressured by the government to act inconsistently with the commands of her God is placed in an impossible situation. Ordinarily, we expect citizens to use a rational cost-benefit analysis in deciding whether to comply with a government regulation. When the cost is high, such as a criminal conviction or a substantial fine, we assume that a rational citizen will choose to comply. Madison understood, though, that the cost-benefit analyses are next to useless in settings where a true believer is either forbidden by the government to carry out the commands of her God or directed by the government to act inconsistently with those commands. In that setting, reasoned the Democratic justices, a true believer in the benign grip of divine madness has no choice but to comply with her God. Faced with such a dilemma, and it's a dilemma very serious, very similar to the dilemma in the 16th and 17th century when true believers were put to what was called the test oath in Europe. As Catholics and Protestants alternated in control, both in France and England, if the Protestants were in power, they would drag a Catholic before some tribunal and ask the Catholic under oath, do you believe in Protestant theology, or are you still in the grip of the devil? Now, that true believer is put in an impossible situation. Either the true believer tells the truth and is executed, or the true believer lies and damns her soul for the rest of eternity. That's where the Fifth Amendment right to remain silent came from. The Fifth Amendment right to remain silent emerges out of the recognition that you cannot put a true believer in a situation where they're put to a choice about whether they suffer a secular punishment or violate the Word of God. And Madison understood that. When we look at criminal procedure issues later in Lecture 7, we'll talk a little bit about that. But Madison understood that in the religion clause, in the free exercise clause, that we had to protect the free exercise clause as protecting a believer in that dilemma to the very edge of society's capacity for toleration. That we have to go the last mile to try to see that we do not put people in that situation where they have to choose between their God and their Caesar. Similarly, the Democratic justices fear that a true believer wielding government power while in the grip of divine madness is a strong risk to do everything within her power, including the improper use of government resources and power, to advance the interests of her God. Only a strong prophylactic rule, a strong prophylactic wall between church and state, they believe, can prevent the misuse of government power. So here's some examples. Under the Republican leveling down approach to free exercise, laws that unintentionally impede the free exercise of religion are constitutional as long as the law is rational and it applies to everybody. So under the leveled down Republican free exercise clause, criminal statutes prohibiting drug use generally can be applied against Native Americans seeking to use peyote in religious ceremonies, and there's no free exercise defense. Orthodox Jewish officers may not claim an exemption from military rules forbidding the wearing of headgear indoors. They're not allowed to wear their yarmulke, and they're not allowed to argue that their God requires it, because this is a general rule applicable to everybody, and nobody's intending to harm you. It just happens that way. Old order Amish, who take care of their own aged population, cannot claim an exemption from Social Security. Native Americans cannot insist that a government logging road being built in the forest that runs through a burial site in violation of their religious beliefs be detoured to go around the site. There's no free exercise right to tell the government it's just as easy to build the thing to go around the site as to go through the site, so don't trample on the site. Under a Republican vision of the free exercise clause, the Indians lose that case. And each of these cases are cases that have been lost under a Republican Supreme Court. Under a Democratic free exercise clause, while religious dissenters cannot claim an exemption from the general duty to pay taxes or to refrain from plural marriage, for example, I'll deal with that in a couple of minutes, they are exempt from less critical duties that interfere with satisfying their religious beliefs. The double-down Democratic free exercise clause forbids the state from denying unemployment compensation to a true believer because she has been fired for refusing to work on her Sabbath. The Republican free exercise clause denies her compensation. The Democratic free exercise clause requires the exemption of Amish children from compulsory education laws above the 8th grade upon a showing that they will receive alternative education within the Amish community. The Republican free exercise clause would not grant that exemption. And then perhaps most importantly, and I suspect both sides will do this, it exempts Jehovah's Witnesses' children from compulsory flag salutes and making them violate the deeply held tenets of the Jehovah's Witnesses Church, that you cannot recognize the supremacy of the secular being in this world. Similarly, under a level down Republican establishment clause, we just talked about the level down or double down, the Republican or Democratic free exercise clause. Shift would be now to the establishment clause. Under a level down Republican establishment clause, government action that aids religion is valid as long as it's not intended, as long as you can't prove that it has a purpose to advance religion. And as we saw in Lecture 2, when we were talking about purpose in creating obstacles to vote, it is very easy to hide the purpose. Very, very easy to prove a purpose that legislators don't want to have you see. So as long as they don't make a mistake and explain the purpose, and as long as it's available to both secular and religious institutions, and as long as it's aimed at advancing some sort of secular interest, there's no limit on the amount of aid that can be given to religious institutions. So in a level down Republican establishment clause, you can give financial aid to religious schools in the form of school vouchers, tuition credits, divinity scholarships, computers, textbooks, everything except paying the salary of the teachers. Can be given as aid to a parochial education. Under the Democratic Establishment Clause, any government behavior that substantially advances religion is suspect. It's forbidden because of a prophylactic wall between church and state that says, look, we'll never be able to prove purpose, but we know what the real purpose of this stuff is. And so we impose a prophylactic rule because we can't prove the purpose. Under the double-down Democratic Establishment Clause, public officials perceived in the grip of divine madness are prophylactically disabled from aiding religious institutions through tuition vouchers, scholarships, grants, computers, and the other absolute river of government funding that now goes for religious education. Now, I should say something about the consensus constitution, because so far all we've done is talk about the Democratic Constitution and the Republican. There is a very important consensus constitution that reads the two clauses. The consensus constitution says if a statute is motivated by hostility toward the exercise of religion, if you can prove the purpose, if you can tease that purpose out of the statute, then the statute is unconstitutional, no matter what the government says its justification is. The leading case is a small town in Florida, Hialeah, Florida, had a group of who practiced the Santeria religion, which is a religion that is part voodoo, part mysticism, but it is a part African tradition. So the Santeria religion was practiced in Hialeah, and the Santeria religion is very closely connected to the ritual sacrifice of chickens. Chickens are slaughtered in the process. Hialeah passed an ordinance that said no slaughtering of chickens. No slaughtering of chickens at all. We don't do chicken slaughter in Hialeah. The Supreme Court struck it down. They struck it down because it was an obvious and patent effort to single out something in a particular religion's worship and make it illegal. And they said you just can't do that. You can't pass a statute designed to drive the Santeria cult out of town. Conversely, the opposite. If you can prove that a law is motivated by a desire to advance religion, then it violates the Establishment Clause, because if you can prove that purpose, it violates the Establishment Clause. So for example, laws aimed at introducing religion into public schools by requiring the reading of the Bible, by requiring the recitation of a prayer, by requiring a moment of silence for prayer or meditation, requiring display of the Ten Commandments, requiring the teaching of creationism instead of Darwinism. They all violate the Consensus Establishment Clause, but because they're all clearly intended to advance religion, and you just can't do that. Finally, under the Consensus Constitution, generally applicable statutes that unintentionally impede religious practice are valid only when they advance a very, very important religious interest. Thus, plural marriage can be banned, even when it conflicts with the tenets of the Mormon religion. Christian scientists can be forced to provide medical care, including vaccinations to their children. Orthodox Jews who celebrate the Sabbath on a Saturday can be forced as well to close on Sunday, despite the economic pressure on religious belief by having to close for 2 days. But the consensus completely breaks down when the applicable rule unintentionally intrudes on religious practice. The Republican justices will uphold the unintentional application. The Democratic justices will strike it down. Now, we've got a stark difference here, maybe the starkest difference that we've seen in any of the lectures so far, although this will pale between the stark difference that we're going to see next week between the Republican reading of the Second Amendment and the Democratic reading of the Second Amendment. You should come packing next week if you're going to have any serious disagreement with what I say. But so far, this is the starkest difference between the level down religion clauses and what I call double down. They're really ratcheted up. Really, the Democrats ratcheted up, the Republicans level it down. The constitutional text doesn't help. You know, when you read the constitutional text, it doesn't really help. A literal reading of the Establishment Clause might even lead you to think that all the Establishment Clause is, I mean, I'll read it to you again. I mean, that all the Establishment Clause is, Congress shall make no law respecting an establishment of religion. What does respecting an establishment of religion mean? If you really took it literally, you know what it means? That Congress is not entitled to pass any laws preventing states from having established churches. Respecting an establishment of religion. I mean, it could literally bear that meaning. And it obviously was not intended to do that. It was not intended to insulate established churches in the states where up until 1830, states did have established churches where taxes supported a particular church. It was obviously not intended to insulate that practice. It was intended to drive that practice out of being, and yet the literal language is consistent with such a reading. So, and history doesn't help either. History doesn't provide a clear answer. Madison, as usual, is the prime mover here, and his remarkable efforts to secure religious freedom in Virginia provide an enduring source of historical data, but also an enduring source of historical data that we all disagree. We read different things into the data. For example, in 1776, Madison persuaded Virginia to place a strong religious freedom clause protecting both conscience and religion into the Virginia Constitution. In 1779, he supported Jefferson's bill for establishing religious freedom in Virginia and finally shepherded it through to final adoption in 1786. But the most important and revealing work that Madison did was in opposition in 1785 to a bill favored by Patrick Henry. Patrick Henry, who was eventually elected governor of Virginia, but he was a leader of the Virginia legislature. He introduced a bill into the Virginia legislature that provided for the continued government payment of the salaries of teachers in Christian religious schools. Now, don't forget, this is before there was a strong public education process, so these were all the schools there were. And what Patrick Henry said is that these schools are going under. We desperately need them. And so what I recommend is that we levy a tax, and the tax be used to support the salary of the teachers teaching in the Christian religious schools and in any other school that happens to be there that isn't Christian. There were none, but theoretically, if there were, it would qualify. Madison drafted and circulated something he called, and has come down to us in history, as the Memorial and Remonstrance, arguing that the proposed legislation violated the principle of separation of church and state. And eventually, remarkably, more than 10,000 signatures were submitted to the Virginia legislature in opposition to Patrick Henry's bill, and it was defeated. But controversy continues today over whether Madison was opposed to the bill because it only aided Christian schools. It actually said Christian schools, or whether he was opposed to any subsidy for religion at all, even if the subsidy were available to all religions and to non-religious private schools as well. my reading of history shows that the proposed bill would have provided support for non-religious seminaries of learning, they were called, as well as Christian schools. So my sense is that Madison was opposed to the aid to religion, even if it was embedded in a bill that aided other secular operations as well. But I can't say for sure I'm right. And there's a good deal of disagreement over the historical data. And so it turns out that neither text nor history solves the problem. You know what solves the problem? We have to look into our own law's DNA. Legal systems have DNA. When I was in law school, Professor von Mehren, who was then the leading comparative law scholar of his generation, used to jokingly say that all comparative law could be reduced to a set of 4 aphorisms. In Germany, everything is forbidden unless it's explicitly permitted. In England, everything is permitted unless it's explicitly forbidden. In the Soviet Union, everything is forbidden even if it's explicitly permitted. And in France and Italy, everything is permitted especially if it's explicitly forbidden. So, and he would say in his first lecture, okay, we can all go home now. You know all you need to know about comparative law. And you know he was right, because what he had just given us is the DNA of those legal systems and the assumptions that operated. Now, I have a fancier way, because I have to get tenure and I have to speak in fancy talk. So I have a somewhat more elaborate exercise. So my elaborate exercise that's useful in plotting and in trying to figure out what the DNA of a legal system is a way of testing for how much real freedom will exist in a system, regardless of the formal written descriptions and regardless of even the formal institutions that exist to enforce them. I mean, after all, if you compared the unbelievably elaborate rhetorical text of the old Soviet Constitution with the very modest, pragmatic text of the United States Constitution, and all you used were the formal words, and all you looked at were the formal institutions, you would predict more freedom in Moscow than in New York City, and certainly more freedom in Moscow than in London, which had no Bill of Rights at all. And of course, you'd be completely wrong. You would have gotten the actual reality completely wrong. Because the degree of real legal freedom in any legal system turns on more than the system's formal words and institutions. It depends in large part on deeply rooted cultural reciprocal assumptions about human nature and the likelihood of future behavior by individuals and by government officials in different contexts. When First Amendment freedoms and government regulatory powers are concerned, 4 sets of reciprocal assumptions are possible about how individuals and government officials are going to interact with each other. Reciprocal assumption 1 is that private individuals are likely to exercise and enjoy their freedoms responsibly unless you can show us that they won't. So the assumption is that individuals can be trusted with freedom. On the other hand, government officials will abuse their powers unless you convince us to the contrary. So you have 2 reciprocal assumptions running in different directions. A reciprocal assumption that says individuals can be trusted, government officials can't. That's reciprocal assumption 1. Reciprocal assumption 2 reverses it. Reciprocal assumption 2 says, under my view of human nature, you can't trust individuals with freedom. If you give individuals freedom, they'll just abuse it. They'll do something terrible with it. On the other hand, government officials can be trusted. And so government officials can be trusted with power. Individuals can't be trusted with freedom. That's reciprocal assumption 2. Reciprocal assumption 3 is that both can be trusted. Reciprocal assumption 4 is that neither can be trusted. I mean, those are the 4 possibilities. And it's quite remarkable that the particular interplay about the assumptions between individual and state regulation is the real barometer of freedom in any culture. Authoritarian legal cultures like China, the old Soviet Union, they will almost always apply their laws, their formal laws that look great, but they will always apply their laws against the backdrop of reciprocal assumption 2. Mistrust of the individual, trust of the state. You put the 2 together, and it doesn't much matter what the laws say, you don't have any freedom. Under authoritarian legal assumptions, individuals can't be trusted because they will exercise their freedom irresponsibly, leading to anarchy, disorder, and the eventual destabilization of society. And government officials can be trusted to exercise their often loosely defined powers without abusing them. Those of you who were here last week, think about this. Sounds like the bad tendency test to me. That's the test that used to be used in the 19th century to decide whether we had free speech. If speech had a bad tendency to cause harm, we assumed it would, because we assumed that individuals would act irresponsibly. And we trusted the government to do something about it. The shift from bad tendency to clear and present danger is the shift from reciprocal assumption 2 to reciprocal assumption 1. Trust individuals, mistrust the state. Legal systems committed to individual freedom like our own almost always apply their laws, affecting fundamental liberties at least, against the backdrop of reciprocal assumption 1, where individuals can be trusted because we assume they will exercise their freedoms responsibly, and government officials cannot be granted overly broad or discretionary power because they will always abuse their powers if given half a chance. Now, this is beside the point, but it's a gross generalization. It's always assumed, I've always assumed, as I've studied it, that French law operates against the backdrop of reciprocal assumption 3. French law plays out where they trust both, and German law plays out where they trust neither. But that's beyond this. All we have to do for the purposes of this lecture is think a little bit about the difference between reciprocal 1 and reciprocal 2 in the context of administering the First Amendment. Now, during the last week's walk through Mr. Madison's neighborhood, I noted how intensely our free speech law turns on reciprocal 1, that we respect and trust the vast bulk of speakers and hearers to exercise their broad freedom of speech rights responsibly, even heroically. Prometheus cursing the gods comes to mind, while simultaneously mistrusting the local motorcycle gang masquerading as government speech regulators. We assume that every inch of power given to a government speech regulator is likely to be abused. And so much of our free speech law, including clear and present danger, the ban on content-based regulation, the strong reluctance to permit regulators to protect hearers, crucial procedural restrictions on censorship, the ban on prior restraints, vagueness, overbreadth, requirement of equal treatment of all similarly situated speakers, they all rest on reciprocal assumption 1. The open question that we have to think about is, should reciprocal assumption 1 operate in the religion clause areas? It's clear that it operates in the speech areas. Should it operate in the religion clause areas? Should we assume that when free exercise of religion is at stake, government officials should be viewed as members of a vicious motorcycle gang? We don't trust them. If we give them any power, they'll do something terrible. Should we view true relievers in their private or public capacity as trustworthy stewards of religious freedom? Now here there is a very interesting and strange anomaly that you can track through the cases. The Republican justices' intense hostility to government regulators, which is so obvious in the free speech cases, is mysteriously absent in the religion clause cases. Unlike the free speech clause cases that uses a pure effects test to trigger searching judicial review, Republican free exercise clause requires proof of a bad government purpose to adversely affect religion before applying strict judicial review, thereby licensing negligent or reckless government officials to impinge on religious freedom unintentionally with no religious check. It has to be because they trust them. If they didn't trust them, they would put them on a much tighter leash. So the inconsistency between the way they treat free speech and freedom of religion is really quite interesting. Similarly, under the Republican Establishment Clause, government officials may funnel substantial aid to religion under a relaxed, indeed a trusting legal standard that asks merely whether the government decision to provide aid to religion is available to everybody and is motivated primarily by a desire to advance secular values. Now contrast the trusting view of government officials under the Republican Establishment Clause with the almost ferocious mistrust of the same officials under the Free Speech Clause when they seek to limit campaign spending by the super rich or to intervene to protect vulnerable hearers. Indeed, under the benign view of government officials present in the current Republican Establishment Clause, Patrick Henry's 1785 bill for the payment of salaries in Christian schools would not violate the Establishment Clause as long as Christian was changed to private. As long as it wasn't absolutely clear that it was intended to benefit, and even though all of the aid would still go to Christian schools, as long as you formally say it can go to anybody under the existing Republican Establishment Clause, that would be valid. And that's exactly the reasoning behind the Republican majority's holding that Ohio's provision of private school tuition vouchers that overwhelmingly benefited children in Catholic schools did not violate the Establishment Clause because the vouchers were formally available to other people in private school, even though there were none, or there were maybe one or two, so that over 96% of the aid went to Catholic schools. As long as it was formally open to everybody, the fact that everybody knew that the real purpose of the program was to funnel money to parochial education was simply ignored by the Republican legislators. Now, on the other, by the Republican justices. On the other hand, the Democrats, their willingness to tolerate a degree of regulation by government officials in the campaign finance or the hate speech area in aid of equality is absolutely absent from the double-down Democratic Establishment Clause that treats government officials worse than members of a motorcycle gang. It treats them as in the grip of divine madness and therefore can't be trusted to do anything. According to the Democratic justices, the recognition of any government power to aid religion will eventually result in abuse. It's also absent in the Democratic free exercise cases that refuse to cut any slack to government regulators when regulation of religious behavior is threatened. So what we have in the end is this extraordinary situation where if you look at the DNA and you look at what's occurring in the same First Amendment, in the religion clauses, it's one type of thinking. In the free speech clause, it's another type of thinking. And the choice is a choice which none of the justices acknowledge making. So what we have is Establishment Clause doctrine, which is chaotic, and Free Exercise Clause doctrine, which is chaotic. A quick look. I mean, I will suggest to you if you want to analyze these cases, you have to look at the purpose cases, the unintended effects cases, and then I want to spend a moment with you on the religious triumphalism cases. The religious triumphalism cases are where somebody wants to display a symbol. Now, religious triumphalism can have two sides. It can be beautiful. Religious triumphalism can reflect the joy and the intense emotional commitment that a believer has when the symbol is displayed. And that's a beautiful thing, and it's a thing that we should appreciate and should applaud. On the other hand, it can have a darker side. The religious triumphalism can be designed to send a message to non-believers that this particular religious group is in charge, and that they are sending a message saying that we dominate. And the amount of litigation that goes on in the Supreme Court trying to decide whether a particular display, a cross, for example, in the middle of the desert that is designed to commemorate the dead in World War I, and that cross has been up forever. And the question is it a exercise of religious triumphalism that we should appreciate and support, or is it an exercise of religious triumphalism that sends a terrible message to non-Christians about the nature of the country? And it's led to incredible. I'll just tell you one quick story, and then we'll break. One of the early cases that I litigated were creche cases. Creche, for years when I was growing up in this country, every town in America had a creche at the town hall during Christmas, had a nativity scene on the steps of the town hall during Christmas as a celebration of Christmas. People began to say, wait a minute, that's not just a religious triumphalism that celebrates Christmas. That's a religious triumphalism that tells everybody else in town, you're a second-class citizen, because the first-class citizens here are really the people who believe in the nativity scene. You're not as important. If you're an atheist or if you're somebody who doesn't believe in the nativity scene, this is a message that says, you're a guest, but you're not a full-fledged member of the community. And so people began to say, maybe we shouldn't allow that. So poor me, I'm a litigator at the ACLU in those days. They send me around the country to crush Christmas. And I get to go from town to town telling the town hall they can't have their creche. My kids used to call me Grinch. Where you going now, Grinch? Which town are you going to take the joy away from of Christmas? So I would explain why, you can't have these symbols. And of course, the people who were displaying the symbols would get smarter and smarter, and the symbols would be different. So we finally came up against Pawtucket, Rhode Island. Pawtucket, Rhode Island had a creche. And in addition to the creche, they had reindeers and elves. So they had reindeers, elves, and a nativity scene. And we get to the Supreme Court, and the Supreme Court rules 5-4 that this is really not a religious display. It is a display of the season. All the Christmas season, and it's as much secular as it is, and therefore nobody could believe that this is an announcement in Pawtucket that Christians are in charge. So when the case came down, I promulgated what has become now one of the major sources of law in Establishment Clause cases, and that is the two plastic animal rule. The two plastic animal rule is that any religious symbol displayed on public property can be lawfully displayed as long as it's flanked by two or more plastic animals of sufficiently bad taste. But if the symbol is displayed in accordance with the dignity that a great religious symbol is entitled to, then the Grinch is coming to take it out. And that's where we are in this very strange religious triumphalism point. I wonder sometime whether we've invested so much time in what I call the law of exterior decorating. To see how many crosses you can take down, how many menorahs you can put up. And what you wind up with is each side trying to struggle to show how powerful they are by the display of the symbol. And I'll just end with the solution. I had a solution, but nobody listens to me. Because I'm not a Democrat, I'm not a Republican, I'm just an academic. So my solution was this: forbid the display of any religious symbol when the religious symbol is the symbol of the person when he's displaying his own religious symbol. You can't display your own religious symbol. You can only display your neighbor's religious symbol. And so you turn the display of symbols into this enormous celebration of toleration. And all the symbols are there. Everybody gets to see the symbols, so we all can enjoy the joyous nature of the season, but you've taken away the darker side of it, which is the attempt to use religious triumphalism to indoctrinate and intimidate, rather than to express unalloyed joy. There is not one person in America that adopts that. However, that's never stopped me before. I still think it's true. So let me end by just saying that Madison was unquestionably right about the nature of divine madness. It is among the most incredibly powerful elements of behavioral psychology that we know. Probably more than sex, probably more than greed. Conscience and religion drive us to behave the way we do. And the key to getting both religion clauses right is to remember that they are designed to protect and to cabin an elemental psychological urge of overwhelming power. Much of our jurisprudence seems to have forgotten that crucial point. By all means, protect religious freedom to the very limits of our capacity for toleration. Believers in the grip of divine madness deserve no less. But protect us as well from state-imposed religion by building and maintaining a prophylactic wall between church and state. Believers in the grip of divine madness cannot be deterred by anything else. Thank you.